Good morning, everyone. Thanks for joining us today. We are going to get started here. We waited a minute or so people could filter in, and thank you for being with us today. We are excited because this is the first Lessons from Litigators in this new year of 2022. We took a bit of a hiatus in what became a very long Michigan winter, and those of us joining from Michigan don't need to know anything more than that. And I am Amy Murphy. I'm a litigator at Miller Johnson. I really enjoy doing these webinars every once in a while to bring you up to speed on new areas of law or updates in law that's been around for a while, as we will be talking about today. I have my colleague, Alex Page here. Alex, why don't you introduce yourself, because you're one of the newer faces at Miller Johnson.
Yeah, I'm Alex Page. I'm an associate in the litigation section as well. And it's my first Lessons from Litigators.
Okay, so we will get going here, and this webinar won't be one of the longer ones. So lucky all of you. We'll get you the hardest hitting information first, and then we'll dig a little bit deeper. And if you want to hang around and hear about how this law has been developing over the past several years. I find it really interesting, and I think you might too. So our webinar today is what to know before you hit record, an update on Michigan's eavesdropping law.
So today we're going to talk about the Michigan eavesdropping statute. As we mentioned, there was a recent decision in the Sixth Circuit just a couple months ago on it, talk about some policy considerations related to eavesdropping, interstate issues, the federal law on the topic, and just other miscellaneous considerations.
Okay, so this is the big topic for today. This is Michigan's eavesdropping statute. Some of you may be familiar with this, some of you may not be. The statute has several components to it. Toward the end of the webinar, we'll talk a little bit about some of those other components, but this is the meat of the matter. This is where a lot of the litigating happens. It's 750-539C of the Michigan Code. It creates a criminal violation. And when you are in a private conversation or not present in that private conversation, and you willfully use a device to eavesdrop without the consent of the parties, you have committed under Michigan law a felony. And it's a serious felony up to 2 years in prison. So the key elements of the Michigan eavesdropping statute are: one, that there be a private conversation; two, that you willfully use a device to eavesdrop; and three, that you do so without the consent of all parties. We'll touch a little bit on a few of these elements. So the private conversation is key. There needs to be a reasonable expectation of privacy. So, for example, when you meet at a Starbucks and you're chit-chatting away, that's not a place where you have a reasonable expectation of privacy. But in a closed-door meeting, you of course do. And then the other key component is this issue of consent. And that's where this recent Sixth Circuit decision has weighed in. That's where a lot of the dispute in the case law happens. What does it mean to do so without the consent of all parties? And the headline is that in Michigan, that element is interpreted to mean one-party consent.
So, as you mentioned, there was a recent decision by the Sixth Circuit interpreting this statute that Amy just explained. So it was just a couple months ago, and the Sixth Circuit held that, as Amy mentioned, Michigan's eavesdropping statute is a one-party consent law, meaning just one participant in the conversation can record without the consent of others.
I always say one-party consent to me really means no party consent, because you don't actually get consent of anyone else to the conversation. You, as the person recording, can consent to the recording, and that is sufficient under the law. It's often called one-party consent. It's sometimes called the participant exception. And the idea is that a participant to a private conversation is permitted to legally record the conversation without the knowledge of the other participants, without their consent. But just so you know, this only goes so far, right? There are these classic eavesdropping cases that involve someone who truly is listening from, from a behind a closed door or in a closet or installing a device to listen in, and nobody knows that that's going on. Those are all different cases. But when you are a participant in a conversation, the key holding here is that you can hit record, tell no one that you've done so, and you have not violated the Michigan eavesdropping statute.
Yes, so in Fisher v. Perron, this was a basic family feud. The plaintiff alleged that his sister violated federal and state eavesdropping law and recorded over a dozen phone calls between himself, his sister, and their two other siblings, where they discussed their late mother's estate and related litigation. And he tried to allege that this violated Michigan's eavesdropping statute. However, the court held that it did not because his sister was a participant.
And so there's we're kind of giving you the lead at the beginning here. So if you want to go grab coffee and be done with this webinar, you can, because you have heard what the law is. We remain a one-party consent state in Michigan, and we'll get into this in a little more detail in a few minutes. In many other states, this is the law. But why is it important that we come to you today to talk about it? Well, that's because the law had gotten really murky really fast. So in 1982, the Michigan Court of Appeals ruled in a case called Sullivan versus Gray that a participant can record without the knowledge or consent of the other participants, AKA the one-party consent rule. There was a significant strenuous dissent in that case that advocated for the different rule, the all-party consent rule, which is something you probably hear every once in a while on a phone call where there will be a notice telling you that you're being recorded, and everybody gets that notice, right? And that's sort of your opportunity to hang up if you don't want to be recorded. So that all-party consent rule was, or sort of the debate over whether to be a one-party consent state or an all-party consent state was squarely at issue in Sullivan versus Gray. And the majority in that panel decision said the Michigan eavesdropping statute is a one-party consent statute. After Sullivan versus Gray from 1982, there were subsequent Court of Appeals decisions in Michigan upholding and relying on or reaffirming the one-party consent rule. And then there were also Sixth Circuit decisions doing the same. So that's, in the interplay here between state and federal law, you've got the state court, the intermediate appellate court, saying, here's what the law is. We're a one-party consent state, at least when it comes to this eavesdropping statute. And then you had the federal Court of Appeals for the Sixth Circuit acknowledging that Sullivan is the law in Michigan. And so one-party consent is the law in Michigan. Then came a case called AFT Michigan versus Project Veritas. Project Veritas is an entity that you may or may not have heard of. They go undercover and do a lot of reporting using things like surreptitious eavesdropping and recording to reveal or uncover facts that they think will be damaging to a party, and then they publicly disclose them. And so they get themselves into litigation fairly frequently as a result. And in this case, AFT Michigan, a teachers union, filed a lawsuit against Project Veritas after a Project Veritas, a person associated with Project Veritas went undercover, claimed to be applying as an intern to work with the union. The union accepted the application. The person was interning. She likely recorded without the consent of the various participants in the room, lots of conversations while she was working at the union, and the union brought a lawsuit. Judge Linda Parker for the Eastern District of Michigan looked at the law in this area. So this is 2019 at this point, many years after Sullivan in 1982. And she says, you know what? I think the Michigan Supreme Court would not agree with Sullivan. So the Michigan Supreme Court has never actually ruled on this question, has never taken up the issue of whether the Michigan eavesdropping statute requires just one party consent or all party consent. And Judge Parker thought that was significant and also thought the dissent from Sullivan versus Gray was correct and that the majority was wrong. So Judge Parker ruled in that case that indeed Project Veritas had violated the Michigan eavesdropping statute because the intern had not received the consent of all parties to the conversations that she recorded. This was a bold decision in a lot of ways because in the federal system, typically the federal court will rely on intermediate appellate court decisions for deciding what Michigan law is, unless there is some sort of significant debate going on in the state court system. So you've got dueling opinions saying one thing or another. But that hadn't happened here, right? Sullivan had been decided in 1982. There was consensus through the years that Sullivan remained the law, and the Michigan Supreme Court just had not weighed in. And so when this separate case of Fisher versus Perron got to the Sixth Circuit said, you know what? The judge in AFT Michigan actually got it wrong. Sullivan is the law of the land in Michigan, unless and until the Michigan Supreme Court rules otherwise. And what's interesting here is that AFT Michigan comes down in 2019. In the interim between that decision and Fisher versus Perron, which just came out this March, the Michigan Supreme Court actually accepted briefing on certified questions in AFT Michigan. So after Judge Parker's decision, the Attorney General of Michigan, Dana Nessel, came to the court and said, you know what, you've just decided that Sullivan versus Gray is wrong. That's a decision that really should be made by the Michigan Supreme Court. We think the question should be shifted from the federal court to the highest court in the Michigan state system, the Supreme Court, where the Michigan Supreme Court can finally weigh in on this and decide. Judge Parker agreed, and so the question did go to the Michigan Supreme Court, but the Michigan Supreme Court has discretion in deciding whether to answer certified questions or not answer them. And in this case, after accepting a whole lot of briefing on the issue from the parties, but also from other interested entities that care about this issue, the Supreme Court decided not to rule on it. So we still have the Sullivan versus Gray opinion from 1982, no Michigan Supreme Court decision weighing in, and the Sixth Circuit, through the years and as recently as in March, affirming that the law is what the Sullivan court says it is, that we're a one-party consent state.
So in summary, we remain a one-party consent state. The participant exception applies in Michigan. The legislature could change the law. They could amend the statute, but have not. Michigan Supreme Court, as Amy mentioned, they declined to rule on the certified question. So they could rule differently, but it has not, and essentially the law in the state is if you record without consent and you're a participant, you can use that recording as evidence and for other purposes. So now we're going to discuss some policy considerations touching on the eavesdropping law. So basically the balancing act here is the right to privacy in your conversations and in your interactions versus implied consent. So the idea of implied consent here is that you decided to be in this conversation with these other participants. And so therefore you, it's implied that you consent to anyone in that conversation recording. So there is that kind of balancing act in policy related to this issue. But as we saw when the Michigan Supreme Court accepted briefing, a lot of different groups care about this issue. Journalists care about this issue, law enforcement. There's a lot of considerations with domestic abuse, domestic violence cases, and prosecuting those cases. There's the classic person wearing a wire, the informant. They are the participant exception and they can record. So that obviously helps law enforcement to not have to get everyone in the conversation's consent. It's just that informants. And then relatedly, prosecutors, this helps them prosecute their cases, get evidence. A lot of civil rights groups care about this issue. It touches on First Amendment, right to privacy, as I mentioned, and basically anyone with a phone, with friends that they call, knowing that they're consenting to a recording of those conversations.
Okay, so interstate concerns. This is important to keep in mind because when we talk about Michigan's law, we're only talking about Michigan's law, and the state's laws differ on this issue. And so when you have a conversation that's happening between people in different states, you have to be concerned not only with what Michigan's law says, but also what the law says in the other states where people in that conversation, are sitting at the moment of the conversation. This was not really as much of an issue in 1982, although we had telephones then, right? So if you were calling someone interstate, it would matter. It certainly has a lot of significance today because we're often in conversations with people in different states and even in different countries through technology like Zoom. So across the country, there is not uniformity on this, but there is a clear majority rule, and that's the one-party consent rule. That's Michigan's rule, and it's the rule in 35 other states and the District of Columbia. I'll just note, you can see on the screen here, some of these states are our neighbors and other states in our federal Sixth Circuit, right? So Kentucky and Ohio. If you're making phone calls or on Zoom with folks in those states, you're in a situation where every state is following essentially the same one-party consent rule, which would mean that if somebody is recording without the consent and knowledge of the other participants, it's all well and good. There are a few true all-party consent states without any exceptions: California, Maryland, New Hampshire, Pennsylvania. So in those states, you have to get the consent of everyone to the conversation before you hit record. A sort of famous example of this, though it's a little bit dated, is going back to the Clinton-Lewinsky scandal and Monica Lewinsky and Linda Tripp. Linda Tripp was recording a lot of conversations with Monica Lewinsky. One of them was in Maryland, one of them was in the District of Columbia. The laws in each of those jurisdictions are different, and so the recordings were not lawful. A minority of states are one-party consent states, but all-party consent states, but have some exceptions. And the typical exceptions are really distinguishing between electronic communications like email and in-person live communications. So Oregon and Illinois, another of our neighbors, have statutes that essentially say you've got a one-party consent rule when you're emailing, but if you're talking to each other live, it's an all-party consent rule. So over email, no one has, I mean, it's sort of obvious, right? You are recording when you write something down in an email. But for your live in-person communication, you need the consent of all parties before you hit record.
Yeah, so in summary, it's safest to assume that the strictest state's law applies. If you want to play it safe, you get the consent of all the parties before you record. As we mentioned, Zoom does this, you hear it, it will say now recording, and that's Zoom playing it smart. They're making sure that no matter where the participants are in the United States or in the world, they're abiding by the strictest state's law and not violating the eavesdropping statute.
Okay, and we'll take, so there's a question that's been asked during the webinar. Can any participant request that no recordings be made? You certainly can make that request in a one-party consent state. So you can ask at the beginning of a meeting that nobody record it. But as it doesn't change the criminal statute. Meaning if someone against that instruction or that request hits record and does record, they haven't violated the Michigan eavesdropping statute. There are other policy considerations or really other legal considerations that we'll chat about here in a second that are relevant to this question, but simply asking that no one record doesn't change the fact that a person simply can record under the eavesdropping statute without violating it.
So now we're going to just touch on federal eavesdropping law, which is also one-party consent law. So very similar to Michigan. We included the federal statute here. It's unlawful for, or it's okay where someone is a party to the communication to record the communication, whether it be wire, oral, over the phone, that sort of thing. So federal law also requires notifications when you're recording phone conversations. So basically, when you call your cable company and they say this may be recorded for training purposes, etc., that's them complying with this law. They're giving you notification that this is recording, and if you say on the line, you are consenting to the recording.
Okay, a couple of other considerations to think about, and some of these probably have come to mind if as you've been listening to us chat about this. The police don't have a reasonable expectation of privacy when they're conducting their policing function. So that's why you see these days lots of recordings of police while they are policing, and there's no issue with that recording. And it goes back to the reasonable expectation of privacy. So when we are going about, our daily lives in public places, we typically don't have a reasonable expectation of privacy. But the eavesdropping statute under Michigan law and lots of other laws still have some, recognize that there are some places where you are entitled to that reasonable expectation of privacy. And so it would be a violation of those laws if there were devices recording you. An example is, in a hotel room. So your private space while you're renting the hotel room, if the hotel owner installs a listening device or a camera without your consent and knowledge, that would be a violation of lots of different states, Michigan, lots of states' laws, and Michigan's eavesdropping law. So there's, as I mentioned at the beginning of this, we've been focusing on 539C, which is the piece of the law that gets heavily litigated and is about hitting record during these conversations that you're privy to. There are other parts of the Michigan eavesdropping law more generally that also make it a criminal and a civil offense to install in a private place devices for recording or observing people without their consent. Okay, and one other thing to keep in mind too is that there are other privacy laws that still apply. So we talked about the fact that there are the various laws in all the states that you have to keep in mind when you're having conversations that are interstate in nature. It's also the case that even within Michigan, it's not simply this statute that governs privacy. So there continue to be these common law invasion of privacy torts. My favorite of which is intrusion upon seclusion. And intrusion upon seclusion touches on a lot of the same things we've just talked about. It's really about a person invading the solitude or seclusion of another person, which in a way that would be highly offensive and, thereby sort of learning some information about a person. So those laws are civil offenses, civil torts, and they continue to apply. It's not as if the Michigan eavesdropping statute has displaced the common law in Michigan. So there are other laws, intrusion upon seclusion being one of them, and the other invasion of privacy torts, which involve things like putting private information about a person into the public sphere to embarrass, or using someone's likeness or image. Those sorts of invasions of privacy continue to be actionable, at least in civil court. And let's see here. Oh, we're kind of getting close to the end here. So one other question has arisen here, or maybe a couple of others. A company may have a policy preventing recording conversations, correct? And that's right. So just because the Michigan eavesdropping statute does not make it a criminal offense to hit record during a conversation without telling anyone, if you are a participant to it, does not mean that you can't go above and beyond that in your own company policies. So you can certainly have a policy in your handbook that says, you're not allowed to record without the consent of other parties. And when someone does so, they are violating your company policy, and that you can do with that what you will, as you would with any other violation of company policy. So it's not the case that you can't go farther than the criminal law. This is simply the eavesdropping statute, at least 539C, is really focused solely on whether it's a violation of criminal law and whether you can be subject to a felony for having recorded. But it's certainly the case that in your company policies, you can go farther than what the Michigan criminal law says. Okay. We've touched on everything that we wanted to touch on. And about, where are we? Ooh, 30 minutes.
Good.
That's my goal with every one of these webinars. If you have other questions, you should feel free to email or call me or Alex.
Yes.
We'd be happy to discuss those questions with you. And really any of your other Miller Johnson team members that you call on, especially in the employment sphere. We know this issue comes up a lot in investigations, and also in sort of, these domestic abuse and family law contexts. So if you don't already have someone at Miller Johnson who you call on for these questions, feel free to reach out to us and we'd be happy to talk with you. It's a really interesting area of law.